In the previous lesson, what we did was introduce the topic of space law, specifically looking at space law from an international perspective. Now, this lesson is going to serve as a dual purpose lesson, essentially, because we're going to be talking about, on the one hand, the history and the historical developments of space law, but we're also going to be taking some time to look at the different sources of space law regulation, specifically looking at the treaty law relating to outer space activities. And this is really going to be the final lesson looking at the concept of space law from an introductory perspective before we get into and start to examine the actual general principles of space law in the next section. So that's what we're going to do in this lesson. So when we focus on the historical development of the field, it's always important to do so because giving a little bit of history of how this era of law developed is useful in giving us an understanding of where the law is situated today. And in fact, in reality, a lot of the treaties that govern outer space activities came around between the 1960s and the 1970s and haven't changed very much since. The most up-to-date and most recent kind of agreement is what we're going to look at the end of this lesson, which is the 1998 ISS agreement. And so therefore, in understanding space law, we have to really understand the history because it is actually quite an old or a very undeveloped area of the law, should we say. And so therefore, at least from an international perspective, it is. And so therefore, the historical development is also important to examine. It's also important to examine because it gives us some indication of the driving forces in history that led to the codification and the treatification of these different areas. So namely, the influence of things like the Cold War and the space race, which of course are very, very influential. So, let's begin by talking about the earliest of developments, and the earliest development arguably begins in the 1930s, before the idea of space exploration was even anything of a particular relevance to anybody. And it begins with the first works on the legal regulation of space being published by a Czech jurist by the name of Vladimir Mandl. Now, Mandl would publish in 1932 a publication titled Space Law, The Problem of Space Travel. And now I'm not going to try and read the other translation, but essentially this is really where we start to see the first and the earliest writings on what happens when we talk about legal implications of going into space. What happens when we do go to space and have space travel and all these things start to take place? How does the law apply in this area? And so this work here by Vladimir Mandl was one of the first and some of the earliest developments in this area. Now, of course, you can probably imagine that because we're talking about the 1930s, this is pre-World War II, we are not going to suggest that Vladimir Mandl's work was particularly influential in terms of the kind of waves that it created at the time, because the idea of space travel was still something of science fiction during this particular period. It wouldn't be until the end of the Second World War where the idea of going into space becomes a lot more prevalent due to the development of rocket technology. And this is really where Theodor von Karman comes into the question. Because von Karman was a rocket scientist, a Hungarian-American rocket scientist, who, and mathematician and physicist and all kinds of other scientific genius that he was, who at Caltech in 1942, so during the Second World War, founded a rocket company by the name of Aerojet. So rocket technology was being developed as what happens in most armed conflicts, including the Second World War, is we see huge advancements in different technologies and scientific fields. So the Second World War is obvious for the ways in which computers were developed in, or at least early ideas of computer technology by, for example, code breakers at Bletchley Park, or where we have rocket technology being developed at Caltech. Or we could talk about the ways in which nuclear technology was being developed in Germany with their nuclear programs that never came to fruition, and of course the ones that did come into fruition in the United States, and even in other places like Imperial Japan had their own nuclear program. So all of these kinds of technological advancements always come into development during armed conflicts. And so in 1942 we see the founding of the rocket company Aerojet. And because this was a company, and therefore companies need a certain amount of legal regulation, the Theodore von Karman actually founded this rocket company along with other rocket scientists, and also with a lawyer by the name of Andrew G. Haley. Now, Andrew G. Haley is one of the most influential figures in the area of space law, because essentially Haley helped found the rocket company and became instrumental in not only the company itself, the kind of legal side of that particular rocket company, but would also, due to the nature of the fact that we're talking about a rocket company, he would become instrumental in the earliest studies of space regulation and legal regulation for outer space activities. And all of this work would eventually culminate in the publishing of a foundational textbook on space law and government, published in 1963. Andrew Haley would also be incredibly important in the establishment of certain international treaties, or at least his expertise on particular principles that should be codified in these treaties that we'll get to later. Now, in this textbook, he makes reference to the celebration of the founding of Aerojet, where it is alleged that Theodore von Karman has said the following. They say, "Now, Andy, we will make the rockets, you must make the corporation and obtain the money. Later on, you will have to see that we behave well in outer space." This is a quite nice anecdote about about the regulation of space activities, but it also is important because it gives us some insight into the earliest developments of outer space technology, and that even during these really early developments in the 1940s about outer space technology, attention was still paid to the legal regulation. Attention was paid to what happens when we get into space. How do we act? How ought we act? What rules should we follow and have to follow when we go up into space? So law was something that you might not think at first instance, if you're maybe a non-lawyer or you're just coming into law, studying this for the first time. You might not think that space exploration and law would go together hand in hand, but it seems like even from the earliest perspectives on space technology, that law was something that was in the back of everyone's mind. So these are the earliest developments in terms of outer space regulation. The space race would increase exponentially the amount of interest in outer space, but also the amount of legal regulation in outer space, and actual codified regulation that we'd actually start to see. So in 1957, the space race would begin. And for those who don't know, who haven't studied the Cold War at any point in their educational careers or have no idea, the space race was essentially a competition between the United States and the USSR during the height of the Cold War, and essentially related to the achievement of space-related technological advances. It ended with the moon landings by the United States, and sort of the common understanding, or the common idea of the space race, is that the United States won the space race because they landed people on the moon, and that sort of ended it all. But in reality, if you look at the achievements by both the US and the USSR during the space race, the USSR, I believe, are far more advanced in terms of their achievements compared to the US. So the USSR, for example, launched the first satellite into space, the first person into space, Yuri Gagarin, I believe the first animal into space. They did the first lap around the moon, and it was just the United States that landed on the moon that really was the trump card. So that, as an aside, that's what the space race was, essentially. But because there was this new interest in outer space from the late 1950s into the sort of late 1970s, 1980s, we have new international agreements begin to take shape. And so immediately as the space race begins, we see bilateral discussions between the United States and the USSR relating to legal regulation. And a year later, the United Nations would establish the Committee on the Peaceful Uses of Outer Space, or COPUS. And the COPUS committee would split into two subcommittees, one relating specifically to scientific and technology and technical ideas relating to outer space, and secondly, for our purposes, the legal subcommittee of COPUS. So we are starting to see actual regulation of outer space ideas take place. We start to see the United Nations establish these kinds of committees. And this would lead to the 1960s International Astronautical Congress, which would meet in Stockholm and looked into the legal nature and the status of outer space and looked towards the creation of certain agreements, international treaties for the regulation of outer space activities. So essentially what happened at this Congress was submissions would be made by prominent authorities, including our good friend Andrew G. Haley, who wrote the textbook in and around the same time as this International Astronautical Congress related to outer space, talking about what the law should say, what the law ought to say in terms of how it operates at the moment, and so therefore started to really get some of these ideas onto paper. And it would lead to the creation and the establishment of two major General Assembly resolutions related to outer space activities. So the first resolution was Resolution 1721 on international cooperation in the peaceful uses of outer space. Emphasis on the word peaceful, because we will get to the first major treaty relating to that has some reference to activities in outer space in a minute, that being the Partial Test Ban Treaty, which relates to the use of military technology in outer space and in other areas as well. The second resolution is Resolution 1962 on the declaration of legal principles governing the activities of states in the exploration and use of outer space. And this is really these resolutions that would eventually lead to the most seminal of codification of outer space law, this being the 1967 Outer Space Treaty. And this is really where we begin to see the series of the treatification of international space law. So from 1963 to 1979, we see a series of international treaties relating to specific areas of outer space law, as well as to general ideas relating to the regulation of outer space and the use and enjoyment of outer space. In total, 6 enter into force with varying numbers of parties signed onto them, and that is relevant for the fact that we measure the success of a treaty, at least in this regard, on the number of state parties and the enforcement ability that those treaties actually have. And so we'll talk about the number of people that sign on, i.e. the number of states that sign on to each of these treaties. So the first of these was the 1963 Partial Test Ban Treaty. This enters into force in the same year, 1963. And you might be familiar with the Partial Test Ban Treaty if you have studied, for example, nuclear law or potentially some elements of use of force law, or maybe even IHL in some regards, because it relates specifically to the use of testing of certain nuclear weapons. So it banned the testing of nuclear weapons in certain areas. So, for example, the atmosphere, in outer space, and underwater. So this is, while not specifically only about international space law, it is still important for the regulation of space activities because it bans the use of nuclear weapons in terms of testing in outer space. The first treaty, arguably, that is only about and is all about outer space activities is the 1967 Outer Space Treaty, which enters into force the same year. And this is just a general treaty which governs the activities of states in the exploration and the use of outer space. Now, from there, we start to see certain specific treaties relating to certain elements of outer space law and certain issues that could take place within outer space. So, for example, one of the issues that could take place in outer space is codified in the 1967 Rescue Agreement, which entered into force in 1968. What this treaty did was regulate activities for the rescue of astronauts as well as the return of objects from outer space that had been launched into space. So it relates to essentially emergency situations whereby astronauts are in need of rescue in outer space. And we, of course, know of a number of instances where this may have taken place, may have taken place and has taken place. For example, with Apollo 13 is obviously the most notable example. In 1972, we have the Liability Convention entering into force the same year. This convention relates to the international liability for damage caused by objects in outer space. So it started to codify a certain amount of liability for activities that take place in outer space. And then finally, we have the two final treaties that have the smallest number of state parties. We have the 1974 Registration Convention, which essentially relates to the registration and documentation of objects which are launched into outer space. So we have a general documentation, a general record of everything that goes up into space. And then finally, the Moon Treaty of 1979, which entered into force in 1984. This Moon Treaty relates, is similar in terms of scope or in terms of regulation to the Outer Space Treaty, but applies specifically to the activities of states on the Moon and other celestial bodies. Now, while the Outer Space Treaty also includes regulation of activities on the Moon and other celestial bodies, the Moon Treaty is specific to the Moon and other celestial bodies. Now, these treaties, as you know, as you can see, vary in their scope and applicability, and they're considered success as well. So each of these treaties have varying numbers of state parties to them, and it is quite interesting that as you go down the list from 1963 to 1979, there is a smaller and smaller number of state parties that are signing on to each of these treaties. So, for example, the Partial Test Ban Treaty has 126 state parties, the Outer Space Treaty has 111, the Rescue Agreement has 98, the Liability Convention has 96, the Registration Convention has 71, and then finally we have the Moon Treaty, which is seen as a failure since it only has 18 state parties to it. Now, the extent to which it is a failure is something that is determined by the number of parties to the treaty. But it should be noted that there is only a select few countries in the world that have space programs and that are looking to create and establish space programs. So even if there are only 18 states that are parties to it, if those 18 states cover every single country that are either have their own space program or are part of an agreement that as part of a space program agreement, like for example the European Space Agency, then that might be still enough to cover all the regulation that you might need for outer space regulation of, for example, moon and celestial body activities. So those are the agreements that have sort of come down through the structure of the United Nations. What about the 1998 ISS agreement, which is arguably, in my opinion, one of, if not the most important, at least for future developments, because I'll talk about why this is the case in a second. So, just as a general background, we're coming up to the 1990s and to the early 2000s. The International Space Station is a modular space station which sits in low Earth orbit. For those who don't know, I believe most people probably have some idea of what the ISS actually is. You can actually see the ISS if you can track it online, and you can see when it flies overhead, which is quite interesting. And essentially what the ISS is, it was a project that was operated in conjunction with numerous states around the world. So it was a global initiative that was established in the late 1990s. And so from a legal perspective, each of these states that are part of this ISS agreement have established the ISS agreement itself. And these are Canada, the European Space Agency, which obviously includes a collection of European states, Japan, the Russian Federation, and the United States. These are all the members of the ISS agreement. Now, I'm not going to talk about the substantive law of the ISS agreement in any great detail, because you would know that section, I believe, 4 or section 5 of this course is going to cover the law relating to the International Space Station in more detail, because it is a law in and of itself. But we should note that the ISS agreement is relatively complex and is relatively sophisticated in its ability to regulate certain legal activities on the International Space Station. So, for example, it includes provisions related to the jurisdiction of the agreement on the ISS, regulation of intellectual property rights, agency leadership. So one of the main elements of the ISS agreement is that NASA are the lead agency in coordinating the agreement itself, as well as criminal procedures for those who potentially commit crimes on the ISS. And so there is procedures for criminal prosecution within the ISS agreement. And what I think is important about the ISS agreement, not just because of how sophisticated the legal regulation is, but because it may well serve as a useful template, or potentially just the a template for agreements establishing other colonies on other celestial objects in the future. So we are seeing in the last few years, in recent years, with the establishment of SpaceX, with NASA having a renewed interest in going into outer space, with other countries like India and China developing their space programs, should I say. We are seeing with all of these new initiatives in international space regulation, or at least international space exploration, that there is going to be likely future interest in colonizing other areas within the solar system, and this is becoming a more and more of a reality and something that can be done in the future. And so therefore the ISS agreement could serve as a very useful template for future agreements on the establishment of colonies. So for example, potential colonization of the moon, or even potential colonization of Mars, if Elon Musk is to be believed. And so therefore the ISS agreement could serve as a useful potential for a useful template for potential future agreements. Now, like I've mentioned already, the next series of lessons is going to look at the legal status of outer space in more detail, and talk about really where space begins, the domain of human activity in space, as well as some of the core and general principles of international space regulation, i.e. things like this idea that we might see from, for example, the International Law of the Sea, which is this idea of a common heritage of mankind, of international of space, of outer space, should I say. Now, you might be interested in knowing, just as a quick spoiler before the end of this lesson, that the idea of the common heritage of mankind is often cited when talking about the ocean in terms of on the high seas for international space, for International Law of the Sea, but it derives from space law, so it comes out of space law, not the other way around. So we'll talk about all of these different things in the future lessons that are coming up.